Good afternoon, ladies and gentlemen. Can we please all stand for the Philippine National Anthem to be led by the UP Law Charivari? Take your seats. To give us the welcome remarks for this afternoon, I'd like to call on Dean Danilo L. Concepcion.
Magandang hapon po sa inyong lahat. Distinguished guests, led by retired Justice of the Supreme Court, Vicente Mendoza, the Deputy Ombudsman for Luzon, Francis Ardilesa, the former College Secretary, Professor Laureta, our professors, our faculty members, students of law, former colleagues at the CCB Salazar Law Offices. Good afternoon to all of you. Welcome to the 11th UP Law Centennial Lecture to be delivered by Justice Florentino Feliciano. The title of the lecture is Formidable. The Ordre public dimensions of confidentiality and transparency in international investment and trade arbitration, balancing institutional values. The expansion of the global markets has led to the development of international investment and trade arbitration as an essential tool for dispute resolution on the international plane. The need for foreign investors to boost the local economy through the infusion of capital and the creation of jobs cannot be denied by developing countries such as the Philippines. Simultaneously, foreign investment demands security and the placement of adequate remedies in case of breach by the states. With diplomatic channels oftentimes unavailable to private entities and domestic remedies insufficient, international arbitration provides an equitable solution to the needs of all the parties concerned. In spite of the advantages mentioned, awards resulting from international arbitration are usually challenged and oftentimes restricted when enforcement of the same is refused by domestic tribunals on the ground of conflicts with public policy principles. Luckily, we are blessed to have today the presence of an expert in the field and who graciously agreed to impart a portion of his time and knowledge to all of us. There are only a few people who need no introduction in the legal profession. They belong to a class to which our guest speaker belongs. He is universally recognized as an expert in the field of international arbitration, not only in the Philippines, but the whole world. Without a doubt, it is a great privilege for all of us to have him before us today to deliver this lecture. I welcome you to the Malcolm Hall of the UP College of Law on the celebration of its centennial year. Good day to everyone.
To introduce our speaker for this afternoon, I'd like to call on Professor Rafael A. Morales, Managing Partner of CSIP Salazar, Hernandez, and Gatmaitan Law Offices, and a member of the UP Law Centennial Commission.
Dean Danilo Concepcion, Justice Mendoza, Professor Laureta, and other members of the faculty, guests, students, friends, ladies and gentlemen. I am honored to introduce our lecturer this afternoon in the person of Mr. Justice Florentino P. Feliciano. Justice Feliciano finished his Bachelor of Laws in this College of Law, magna cum laude, and class of valedictorian. Before that, he completed his Bachelor of Arts from the University of the Philippines, summa cum laude. He proceeded to Yale University School of Law for his Master of Laws and doctorate in juridical science. While at Yale, he worked with Myers S. McDougall, and their collaboration resulted in the co-authorship of 2 books, namely Studies in World Public Order and Minimum World Public Order, the Legal Regulation of International Coercion. Justice Feliciano is currently Senior Counsel at CSIP Salazar, Hernandez, and Gatmaitan, where he was a partner for nearly 25 years and where he served as Managing Partner in 1983 until 1986. At CSIP Law, he was counsel, negotiator, and legal advisor to corporations engaged in pharmaceutical manufacturing and distribution, mining, petroleum refining and distribution, and banking, among others. In 1986, after many years in law practice, Justice Feliciano was appointed as a member of the Supreme Court of the Philippines, where he decided a large number of cases on commercial law, tax law, commercial arbitration, and the administration and recognition of domestic and foreign arbitral awards. He was elected to the appellate body of the World Trade Organization, first as a member in 1995, and then as chairman in 2000 to 2001. There, he contributed substantively to the burgeoning jurisprudence of international trade law. Justice Feliciano has been active in the field of international arbitration, acting as both an arbitrator and counsel in numerous international commercial and investment arbitration disputes in the International Chamber of Commerce, the International Center for Settlement of Investment Disputes, the Stockholm Arbitration Institute, the China International Economic and Trade Arbitration Commission, and the Arbitration Tribunal under Article 15 of the 1982 UN Convention on the Law of the Sea. He also served on the Asian Development Bank Administrative Tribunal. Justice Feliciano is a member of the World Bank Administrative Tribunal and Senior Advisory Council on the Southeast Asian Program on Ocean Law and Policy. He was also elected to the Institut de Droit International and the Curatorium of the Hague Academy of International Law. In 2005, he was elected an honorary member of the American Society of International Law. He also is a member of the Japan Commercial Arbitration Association in Tokyo, the World Trade Law Association's Governing Council in London, the International Development Law Institute in Rome, the International Institute of Humanitarian Law in San Remo, and the Asian Society of International Law. He served at the Department of Justice, among others, as a legal advisor to the Philippine negotiating panel, for instance, in the renegotiation of the USRP military bases agreement, and the Philippines' claim to Sabah. In July 2003, he was appointed by the President of the Philippines as chairman of the Special Fact-Finding Committee to look into the causes of the 2003 mutiny in Makati City. Justice Feliciano served as a lecturer for a number of years at the Yale University School of Law and the University of the Philippines College of Law. He has also lectured at the Hague Academy of International Law and at the Center for Studies and Research of the Hague Academy, the U.S. Naval War College, and the University of Bielefeld, among others. He has authored numerous publications in the field of domestic and international law, international investment law, and international arbitration. The list is very impressive, to say the least. Truly a national treasure in the field of law, ladies and gentlemen, Mr. Justice Florentino P. Feliciano.
Good afternoon. I am very pleased to see you here. I did not expect as many as of you who actually showed up. I would have been happy with 1/3 of your number. And I don't blame you if after the first 15 minutes you quietly disappear. Now, I'm not going to deliver to you a formal type lecture. I want to talk about some things relating to arbitration. And I'm going to start from where I started, which is from the very beginning. And what I have to tell you is not particularly not particularly great or unusual. But I think and hope that you will try to understand that what I will be trying to convey to you is essential for beginning to understand why arbitration, why international arbitration, and what the heck is international arbitration. Now, because I am currently afflicted with a nasty cough, if I stop sometimes and drink some water, you're quite at liberty to do the same thing. Huh? I should like to begin by thanking Dean Concepcion and whoever else is responsible for this afternoon. There was a time when I did not need to worry about gathering people together to listen to me. But today that's very difficult. Let me tell you a little secret. I am described as senior counsel in the law firm that I used to be part of. That's what they tell me. But of course, that doesn't mean that they listen to me at all, you know. As a matter of fact, they make it a point to disappear when I'm likely to show up. Okay? Now, I do want to begin by acknowledging the assistance given to me by a number of young people. I will mention some names. The list is not exhaustive. No? I'm sure I've forgotten some people who have helped me in the course of developing this topic. First one is Mayan Rosales. No? It's a young lady at CCP Law. Then there is a chap who is not so young. His name is Nelson Antolin. You know. There is another really young lady, Rebecca Khan, who is now in the office of the Solicitor General. Then she did her LLM at, is it American University or is it Georgetown? George Washington, yes. And then there's a young lady by the name of Jane Yu. I don't know if she's here today, but I should not forget to mention her. And another chap, Jose Florante Pamphilo, young man who had the misfortune of being assigned to work with me on a case, but whom I'm very happy stuck with me and the team, you know. Now, before I start talking about confidentiality on the one hand and transparency on the other in the area of international arbitration, I think it might be useful if I said something by way of introducing the topic of international arbitration. Let me mention firstly why it is, you know, when I was elected to the appellate body of the WTO back in year-end 1995, that's a long time ago, the first body, the first group that constituted the appellate body, we were 7 in number, and I discovered very quickly that I was the only one who had been a judge before going to before election to the appellate body. That tells you a lot of things. It tells you a lot about the history of the institution. About the history, let me tell you, before the effectivity of the Marrakesh Agreement, what we call today GATT 1994, international arbitration was really an exercise in diplomacy. And those of you who have done your work in UP in the field of political science know that diplomacy is of many kinds and utilizes many different instruments, from the very gentle and courteous kind to the very rough and violent kind. There was no such thing as international trade law. Let me tell you that the head of legal in Geneva, in WTO, had been brought up under the regime of the 1947 GATT. GATT is, by the way, is the General Agreement on Trade and Tariffs. No? His name was Frieder Ressler, a very brilliant chap. But he believed, that there was no such thing as trade law, and that you could not use law as an instrument for resolution of trade disputes. What did you use? You used diplomacy. And what did you do when diplomacy was exhausted? Well, it's up to you. Depends on how many warships, particular countries have. Or how many marines you could afford to land there. And therefore, Mr. Ressler, being an honest person, when he discovered that the whole purpose of WTO was to judicialize trade law, was to utilize norms, legal norms, for resolution of trade disputes, he resigned, left. And so there was a new setup after that. There's no need to mention any further names, but no. I wanted to tell you that perhaps the simplest way of describing very quickly international arbitration is to refer to a very simple-minded kindergarten type of typology. There are two general ways by which you can classify or categorize international arbitration. First, according to the parties who are or become parties to an international arbitration. And secondly, according to the kinds of disputes which are brought before the International Arbitral Tribunal for settlement. Now, firstly, I should mention that when both parties to the arbitration are private corporations, though of differing nationalities, and the issues raised are basically, or generally speaking, issues of commercial law, which involve generally the private economic or trade interests of the two parties. What do you have? You have international commercial arbitration. Example, you may have in the late 1970s, there was a case that was brought before the International Chamber of Commerce that involved the question of who was entitled to certain assets and companies left by Mr. Menzi, Mr. Menzi. And I happen to have been appointed as a member of that tribunal. So you simply had two kinds of claimants competing with each other to establish claims to ownership or succession. I'm not quite sure who won and whether or not it was according to law. Okay. So the first kind, when the parties are both private entities, the arbitration is really basically a contractual and commercial matter. Now, who are the entities? Which are the institutions which deal with the international commercial arbitration? Well, the most prominent, of course, is the International Chamber of Commerce. I don't know how many of you have heard of the ICC. The headquarters of the ICC is in Paris. They have a large group there, and it's quite a impressive institution. I was fortunate enough to have been designated as a representative of the Philippines, and I sat there for a number of years. But the point I'm making is that these are disputes between two private entities. Just like you have corporation law problems arising before the regional trial courts of the Philippines. Now, other entities involved here. You have the LCIA. That's the London Court of International Arbitration. It's based in London, of course. It is a private international organization, much like the ICC. Okay. Then you have another couple more illustrations of what I'm talking about. You have the Hong Kong International Arbitration Commission, and you have the Kuala Lumpur, International Arbitration Commission. And I shouldn't forget to mention the Singapore International Arbitration Center. Now, when the parties to the arbitral case are not both private entities, but are rather a private entity, a private corporation, and on the other hand, a sovereign state, you have what is known as an investor-state corporation, arbitration. Okay, that is the form in which investment arbitration takes. It is therefore private entity versus a sovereign state or a state-owned entity. And you may ask immediately, those of you who are hearing about this topic for the first time, what state is involved? Basically, this is the state in which an investment had been made or had been claimed to have been made by a private company or corporation. In other words, the sovereign state or host state that is alleged to have received injection of foreign investment. Okay. Now, examples. Well, there are any number of examples. There are hundreds, thousands of cases of this type. But the prototype the prototype of international organized entity is the ICSID. Let me acknowledge the presence of the Honorable Solicitor General of the Philippines, Mr. Jose Anselmo Cadiz. He represents the Philippines on all legal matters outside the country. And he has had the burden, the back-breaking burden of dealing with the international arbitration cases which he inherited from the prior administration. Now, so you have so far two. The first type is international commercial arbitration. The second type is international investment arbitration. The third general type is arbitration which takes place where both parties, the claimant and the respondent, are sovereign states. What am I talking about here? Here I'm talking about arbitration taking place within the institutional framework of the WTO. WTO dispute settlement is really international trade arbitration. But it is state-to-state arbitration, one member state against another. You will not find any case involving or being brought by a private corporation before the WTO. But having said that, let me tell you immediately that the moving spirit behind the various sovereign states who are either claimants or respondent states are private sector companies. They are the ones whose very real interests are affected one way or the other by a trade dispute when it arises. So that is, it's important to bear that in mind. If you want further examples of state-to-state trade arbitration or even investment arbitration, I can mention to you Chapter 11 disputes under the NAFTA. You know what NAFTA, if you heard about NAFTA, that is the North American Free Trade Association, consisting of 3 sovereign states, Canada, Mexico, and the United States. The NAFTA provides for different kinds of arbitration. You note that I refer to Chapter 11 because there are Chapter 19 disputes, which are state-to-state disputes completely. Chapter 11 are investor-state disputes. So you have both types under the aegis of NAFTA. Okay? By the way, I want you to feel free to raise your hand if I say something peculiarly esoteric or something not difficult to understand. I invite you to raise questions because if you keep them in your head, you're likely to forget them. Now, let me say this as a general proposition. The extent and importance of the role that confidentiality on the one hand and transparency on the other hand play in international arbitration depends upon the kind of arbitration that is involved and depends upon the kinds of issues which are raised there. You see, take international commercial arbitration, problems relating to ordre public, public order, very rarely arise in private in international commercial arbitration. Why? Because only private commercial interests are generally discussed there, generally disposed of there. On the other hand, in state-to-state arbitrations or in investor-state arbitrations, those are the kind of arbitrations where important questions of public policy, of ordre public, which are sought to be managed by the concept of confidentiality. There they arise, and you may have very important questions of public international law and international commercial law, international banking law, and so forth, and so on. Okay? Now, before I go any further, let me try to say that confidentiality in an operating sense, or should I say in an operational sense, generally refers to restriction of access to certain types of information. What types of information am I talking about? Information relating to the existence of an arbitral case, the kind of issues which are raised before that, in that case, the identity of the arbitrators, the witnesses on either side, every aspect of either investor state and state-to-state arbitrator become subject to the requirements of confidentiality. I don't know how many of you have ever heard of ICSID or seen the rules of ICSID. The first, or of the ICC in Paris, the first paragraph of which always referred to the confidentiality of the arbitral proceedings. Now, I'm going to talk to you a little bit of why is confidentiality so important in either investor state or state-to-state arbitration. In private, rather in international commercial arbitration, it's much less important. You will also ask yourself, what is the purpose of confidentiality? The purpose of confidentiality has historically been to encourage recourse to dispute settlement, especially when one or the other party would not go to a dispute settlement of a judicial or quasi-judicial type without confidentiality. Secondly, in investor-state arbitrations, confidentiality becomes very important where precisely the arbitration case arises because the private investor company has very little confidence in the judicial, national judicial processes of the respondent state. It saddens me to have to say that that is really the most important reason why investor-state arbitration arises. That's because the foreign investor has very little confidence in the domestic judicial system of the host state. Maybe I should tell you that historically this type of arbitration began in the early 19th century, during the time when Napoleon, I assume everybody's heard of Napoleon, brought troops and conquered Egypt. They fought a war. He fought a war with the Khedive of Egypt, and of course won the war. Otherwise, he wouldn't be Napoleon. So the question arose, how do disputes involving French companies, French investors, how are they supposed to be resolved? Now I have to, you will presumably recall that Egyptian law, Khedive law in the early 19th century was simply Islamic law. Now, Napoleon, whatever else he was a Christian, no? Well, Catholic as a matter of fact. What did they do to this? Because you had problems of French companies being worried about being subject to the jurisdiction of the courts of Egypt, especially because Napoleon had beaten Egypt. So they solved their problem by establishing the mixed arbitral courts. And these courts were set up, and they were extremely successful. The people who became judges or arbitrators of the mixed arbitral courts of Egypt were very high intellectual and moral caliber. As a matter of fact, well, I'm the only one old enough. I met one of the last remaining members of the mixed arbitral court, a man by the name of Jasper Brinton. He was an American, but he was a member of the mixed arbitral tribunal. So what really happened there was this. You had French companies operating in Egypt, but who were not subject to the jurisdiction of the courts of Egypt, the National Court of Egypt. They were subject instead to the jurisdiction of the mixed arbitral courts. So you begin to understand this. The French were very reluctant to submit themselves to the jurisdiction of the Egyptian courts, especially because the courts had been beaten. I mean, Egypt had been beaten by Napoleon. Now, there are many other types of situations when investor-state arbitrations arise. I've given you one general example, which is very common even today, even though it is not spoken in the terms which I have just used, because very few countries will orally admit that their companies have very little confidence in the courts of X country. You will have, you won't have any international trade. You won't have any flow of international investment if you start talking in those terms. But the reality of the situation is there. Now, but that is not the only situation when this arises. Investor-state arbitration also arises where one party, most of the time the private investor entity, has done something in the course of injecting some investment in the host state, which is contrary to the law or public order of the host state. Now, we have a lot of examples on this. The cases which are ongoing involving the Republic of the Philippines are of this type. You have foreign investors who bring in money, yes, but they enter into agreements, into partnerships with local entities, and so many times they don't know with whom they are partnering, or they don't care. And they wind up having rather very difficult and problematic local partners. I'm not going to mention names here, although I have a few in my head on this. And the Solicitor General is very smiling because he has exactly the same people in his mind. But the point I wanted, one point that should be made in this connection is that the consent of the host state to arbitration before an international tribunal. An international tribunal is one that is not subject to the control of the respondent state. But the consent of the respondent state is necessary because what the respondent state is doing is waiving a portion of its territorial sovereignty. Normally, all disputes of any and all kinds which arise inside the territory of a state are subject to, and normally subject to the local court system. And the applicable law is the law of the host state. Okay? But when a state agrees to go to international investment arbitration into an investor-state type of situation, the sovereign state, the respondent state, has in effect surrendered a portion of what would otherwise be its control over the situation. Now, it is this aspect which gave a great deal of difficulties to exceed during its birth time. No? A number of years, I've forgotten what year exceed was first adopted. When the Convention for the Settlement of Investment Disputes was first written. Do you know, do you remember the year, Mayan? Well, I've forgotten the year. But I wanted to tell you in this connection, when the convention was first adopted by the same countries who are members of the World Bank Convention, the number of developing countries that joined ICSID was very small. Very small. The developing countries simply refused to come in. They were very worried about it. The leaders of this group were the South American countries. You know? And for years, the capital exporting countries led a movement trying to persuade the developing countries to join. It took them many years before enough developing countries joined so that the convention could go into effect. These were the Latin American countries, and the Philippines joined this group. This was the time of Governor Andres Castillo of the Central Bank. You know? For years, the Philippines refused to be a member of ICSID. Eventually, because of the necessity, the pressing need presented by the need for foreign capital, for foreign investment, more and more countries joined. Now, this morning, I received an email notice saying that the Republic of Venezuela has just formally withdrawn from the ICSID Convention. And it's not just Venezuela who's involved. Ecuador, I suspect, will follow very quickly, and Peru. No, I don't know who else. But those are the... Now, I know that Venezuela is not particularly attractive to many Western, North American countries. No? You remember that the president of Venezuela, who happens to be suffering from cancer, accused the United States of spreading cancer in South America. So that kind of relationship is rather difficult. But today, formally, diplomatically, they have withdrawn from ICSID. Question, what happens to the cases which are already ongoing? Answer, they remain. You cannot withdraw from existing cases by simply withdrawing from the convention. The withdrawal from the convention does not affect those cases, but they will affect future potential cases. No? I must rest and take a little water. Feel free to raise any question you want at this stage. What I'm really saying is that the consent of the respondent state that is necessary before it becomes bound to by obligations to go to arbitration is necessary. The consent of the sovereign state is necessary. Now, how is that consent manifested? Normally, that is manifested on a case-to-case basis. The company that thinks it's got a problem goes to its diplomatic service, and then diplomatic discussions are open with and that consent is obtained by diplomatic case-to-case basis. But today, that consent is normally given or is normally found in the form of consent provisions in BITs. I don't know how many of you know what BITs. Those are bilateral investment treaties. An important portion of each BIT. And by the way, there are about 2,000 to 3,000 individual BITs today. They provide for modes of dispute settlement between investors of one country and the other sovereign state involved. Now there is a brilliant chap by the name of Jan Paulsson. Jan Paulsson is a Swedish man of original Swedish nationality, but today is of French nationality. Irrelevant statement. A few years ago, he introduced me to two of his girlfriends who were both Filipinas in Paris. Irrelevant. But Mr. Paulson, today, if you had to name the 5 most distinguished members of the international arbitral community, he would be in that list. He invented the theory that by entering into a BIT and by providing for modes of settlement, the sovereign state has already given its advance consent by the treaty, which cannot be withdrawn. And therefore, there is no need for a case-by-case consent as these cases arise. That's the problem which I wanted to mention, which the umbrella clause was trying to not only utilize but to expand, so as to bring everything, every kind of dispute, contractual, non-contractual, public, administrative, to the jurisdiction of an arbitral tribunal. At this point, I wanted to close this portion of this talk by saying that here you should contrast the ICSID with the PCA. You know what the PCA is? That is the Permanent Court of Arbitration. That was created back in 1894. And the Philippines became a member about 2 years ago. Okay, there is an institution for arbitration, and first, beginning it used to be state-to-state arbitration only. Today, it covers both investor-state arbitration, and most importantly, the consent that is exhibited by a country becoming a member of the PCA does not perform the required consent, because in addition to that accession to the Convention of 1894, the Hague Convention of 1894, which, by the way, was reinforced and amended in 1907, the individual specific consent of the state is required as particular specific cases arise. So the Paulson theory of advanced comprehensive consent is expressly rejected by the PCA. This was the little comment which I offered our Department of Foreign Affairs, and happily, we became a member. The Philippines became a member of this. Now, I want now to speak more directly to the problem, to the concept of confidentiality and transparency. Why is confidentiality a value in arbitration? Why do all the arbitration conventions start by saying all arbitral proceedings are confidential? What is the public interest involved in maintaining the requirements of confidentiality, especially in investor-state arbitrations? Okay? That's really the most important question. Well, let me tell you that at the end of the day, the important thing is that without the requirement of confidentiality, the home state of the investors will not enter into those agreements. In other words, the foreign investment capital will not start flowing unless there is a dispute settlement provision there and unless it includes arbitration with the requirement of confidentiality. Now you may ask, why are investors and their home states so dead set about confidentiality? I don't have a complete answer to that. You know. If there is a public interest in the flow of capital, foreign investment, especially FDI, foreign direct investment, then there is a public interest in confidentiality, because without confidentiality, the taps won't open, the investors won't come, for the reasons I've indicated earlier to you. They worry about subjecting themselves to the domestic courts of the host state. But I guess what I'm saying is that the initiation and the sustainability of the flow of investment capital will be much reduced unless you had a dispute settlement process like international investment arbitration, of which confidentiality is important. I don't blame you if by now you are two-thirds asleep. Now, the really difficult problems which arise in this connection relate to what is covered by the requirement of confidentiality. And what happens when there is a problem, a conflict between the requirements of the public order of the host state and the interest of the foreign investor. The foreign investor wants, of course, to keep everything quiet, underground if necessary, especially if they spend a lot of money in procuring the contract that they are trying to enforce, of course. Let me assure you that corruption is not a monopoly of the Philippines. I will mention to you my personal experience. I was presiding arbitrator in the case of Petrol versus Azerbaijan. Azerbaijan is one of the former Soviet republics with a lot of oil resources. Petrol was a Dutch company. Of course, I didn't know about this, what had happened before. But in the course of the oral hearing, when the chief representative of the claimant was testifying as a witness, he probably lost control of himself. He began to brag how important, he was in the organization, and that it was he who really got the contract from Azerbaijan. And right then and there, in front of the tribunal, in the course of cross-examination, he said, I paid money to the officials of Azerbaijan. Now, that is not intended to impress us, no, the members of the tribunal, but we were all dumbfounded, not because bribery had been committed, but that he was openly confessing to it in front of the tribunal. Now, as you might suspect, the case didn't last very long after that. Both parties, the claimant reached compromise agreement with Azerbaijan very quickly after that. That's one example. And this one I can swear to you about. Another example, also personal in kind. I was sitting in a ad hoc tribunal of ICSID where Siemens brought the case against Argentina. Siemens wanted to annul an award given by other tribunal in favor of Argentina. But in the course of evidence production, Argentina, I don't know how they did it, they obtained evidence showing that Siemens had bribed Argentinian officials. Again, I think Siemens, at least the representatives there present, had personally no knowledge. They were dumbfounded. They asked for a recess of about 1 hour. And after 1 hour, we resumed hearing. And then, to our great surprise, but to our great satisfaction, Siemens withdrew its complaint, confessed again that that what the Argentinian lawyers had said had happened, did happen. So the case was withdrawn, and Siemens apologized in public before the tribunal to Argentina and made amends. Okay? I wish other German companies might be similarly inclined. The thing is, there was a time when if one spoke of corruption in international arbitration, you would be kicked out very, very quickly. But today, evidence is coming out that corruption takes place very often, much more often than is confessed by other countries. No? So don't think that we have a monopoly, corruption. But I'm not trying to defend our officials who are guilty of corruption. Please understand that, okay? It's just I feel so depressed when people I meet abroad, they tell me about, or they imply how that the Philippines does not enjoy a good reputation. Well, that is a problem shared by a lot of countries. No? Now, what are the elements of public interest which are at stake? No? In this situation, I told you that confidentiality basically means restriction of access to information. What kind of information are we talking about here? It is, I will give you a list of items. And here I must say, I acknowledge my debt to Nigel Blackaby. Nigel Blackaby is a young English lawyer, or maybe not so young anymore, who's a partner of Jan Paulson, Freshfields. He wrote an article a number of years back on this topic and tried to specify what the elements of public interest which become involved here. And I found that list very useful, and I wanted to give you an idea of what this list contains. He said that there is a public interest in knowing about the existence of the state-investor dispute. Because if you don't know that there was this investment dispute, you never even get to first base, no? Understanding it. Secondly, the nature and there is public interest in knowing about the nature and the consequences of the facts which are constitutive of the dispute. There are many different types of disputes, no? Let me tell you that I mentioned Germany. There was a time when under German domestic law, money spent in bribing foreign public officials was a deductible business expense. However, that has now changed. Germany, the Federal Republic of Germany, acceded to the OECD Convention, and therefore it obligated itself to change its domestic law and remove that. There is also a public interest in knowing which is the applicable law of the contract or undertaking that is at stake. There is a strong public interest in knowing not just what was or is the applicable law, but the extent to which applicable law was observed at the beginning and in the course of the injection of foreign investment into the host country, and the legality of the treatment meted out by the officials of the respondent state. I'm not trying to lay all the blame on the foreign investors. Far from it. Far from it. There are countries like the United States which have very stringent laws. No? You all heard of the FCIA. No? I'm sure you have heard about that. And finally, if let me add, there is a strong public interest in knowing about the regulatory authority and the manner of exercise and the extent to which the regulatory authority is vested in the officials of the respondent state. And also, there is a strong public interest in the access or the lack of access of private individuals to the arbitration process that is going on. No? If the arbitration process requirement of confidentiality is very strictly enforced, then very few people will know about it. But if the requirements of domestic public order public are held to overcome the requirements of confidentiality. In other words, where transparency is the more important than private parties, individuals may be able to intervene in the process and perhaps supply evidence which otherwise might not be available to the respondent state. Because both the foreign investor and the local officials who receive the bribes are not anxious to make public this evidence. As a matter of fact, they will do almost anything. And sometimes, including murder, they hide, conceal evidence of corruption. Unfortunately, that has already happened here in the Philippines. Dean, I don't know whether I've overstepped my time already. Perhaps we should open up the discussion. Let me just say that transparency is really the other side of the coin here. And let me say that transparency, at least in the area of international trade arbitration, is becoming quite simply well recognized under the WTO. In what form does that recognition take place? Third parties, third states who are neither claimant nor respondent, they are allowed to intervene in the trade law arbitration before the WTO. Not to the same extent as full parties, but they may reserve a right to be treated as a third party, and then they are entitled to attend special sessions and to submit written memoranda for or against one or the other side. In the WTO case, which the Philippines has just been involved, there were about five other countries who asked for the right to be a third party in the proceeding, and they attended the hearings and submitted memoranda. I wanted to wind up at this point, although I have a few more things to tell you about, but I'm afraid of pushing my luck too far. There is a strong public interest in developing disincentive to corruption in transactions involving foreign investment and trade matters. Don't think that the foreign investors have a monopoly of corruption. The people in charge of trade matters are also open to, vulnerable to the lure of all kinds of incentives. I guess I should shut up at this stage, Dean.
So we will now open the floor for any questions that you may have. We have microphones on all the three aisles. Any questions from our students? Was it too difficult?
No.
No questions?
There are very bright young solicitors of the OSG Sogen who are sitting over there. I'm sure they must have questions in mind there.
Questions from the young solicitors? Especially since your boss, my classmate, is here.
Or perhaps Sogen might wish, it need not be a question, it can be a comment, a statement, agreeing or disagreeing, it doesn't matter.
Solicitor General Joel Cadiz.
Sir, in the annulment proceedings at ICSID, where ICSID chooses the members of the committee, we have observed the inherent bias in favor of the claimants in our recent case, and we have, I think, dutifully stated that the choices of the members of the committee were limited to nationals who are affiliated or who speak even the same language as the claimant. And we have pushed forward for a change in the system. And I would like to have your thoughts because we were in Washington, D.C. late last year on the prospect of our initiative advancing to a change in the system.
Yes, Soljan, I have to tell the public that I was a consult or co-counsel with the OSG. He's talking about the annulment by the ad hoc committee chaired by Tomka, Judge Tomka of the ICJ. By the way, soon after that decision was rendered by Tomka, he was elected Vice President of the International Court of Justice. And I hear that in another few more years, he will be running for President of the International Court. But that's neither here nor there. I believe the Republic understood that there were serious errors committed by the ad hoc committee. They misunderstood the local laws which were at stake, and here we were referring to the anti-dummy law. But they were not alone in misunderstanding what those laws. Our own then Secretary of Justice was not particularly informed about the requirements of the anti-dummy law. Yes, sir. And my own feeling is that the ad hoc committee overstepped the boundaries of its own authority and issued an annulment without really trying to understand what it was that what had happened in the first exit case. And let me mention for the benefit of the public that the Republic filed a memorandum, submitted it to the Administrative Council of ICSID, setting out the reasons why the Philippines felt that egregious error had been committed by the ad hoc committee, and asked that this matter be carefully inquired into so that the possibility of providing measures of relief when this happens, because there is no appeal from a decision rendered by an ad hoc committee. You can't bring a second ad hoc, you can't seek to annul the decision of an annulment committee. Okay? So what the Fraport did was to start again, which they have. Fraport 2 has already been filed in Washington, D.C. And that is now, that's also on the back of the subject. I don't know whether that's helpful.
It helped, sir. My wish is for this year that we have to push forward in the changes that we sought late last year. It's easy for the Administrative Council to put this initiative in the back burner. But I think I'm confident that we will again prevail in Fraport 2. But if this comes up to an annulment proceeding again with the same people or the same types of people being appointed by ICSID, and we didn't have any control over that, then this kind of litigation may go on for a very, very long time. So that is my wish for the first quarter of the year going into the second quarter, that we push ICSID to adopt the reforms that we suggested late last year. Thank you very much, sir.
Yes, sir. I think the gentleman wants to... Go ahead, please.
Yes, sir. Sir, can you introduce yourself so we can address you properly?
Yes, ma'am. Justice, I'm Lito Taruk from the Board of Investments. I commend the efforts that you and the Solicitor General here is achieved at the ICSID. However, at the investments promotion side, it is our wish that while there are remedies that a foreign investor could avail of outside of the Philippines, as you said earlier, generally some investors do not trust the tribunals in the host country. But then, if we can stretch all of the remedies in order not to let arbitration of trade and investment issues, we can do something to remedy it here within the Philippines. That could be a good promotional move. Because whenever a foreign investor gets out of the country on any specific issue, our promotional efforts in attracting investments is generally blasted. In fact, with the Fraport issue, our PPP initiatives are practically dead in the water. That's only my observation, Mr. Justice. And it's my wish that we can do something about it. Thank you.
Well, let me tell you that I share your wish very fervently. That's the same wish that the Sojan has referred to on this. No? Certainly long-term, enduring changes are necessary in our own judicial system. Is there anybody from the Department of Justice here? I don't know on it.
Anyone from the Department of Justice? Apparently not, sir.
Yes, well, I think changes will begin to, there will be increasing agitation for changes in ICSID. I told you about Latin American countries, no? They're worried about it too. Because, well, many times the foreign investor is also correct, no? They are not always wrong. But a lot of things happen. And because of confidentiality, very few people know what's going on. Okay? You can see why very few countries choose me as arbitrator on this matter. Yes. But you have to know the world as it exists. And slowly things are changing. Because what happened when the ICSID Convention first was put forward, when the developing countries refused to join, and only by a strong, vigorous campaign by the capital exporting countries were they persuaded to come in. Now they're beginning to realize this. Listen, it's not easy to get involved in international arbitration, no? Especially as respondent. There, the Soldier might want to add to this matter. But those are the values which are essentially embodied in the term transparency. You know.
Any more questions? Yes, ma'am. Please identify yourself.
Marjorie Ramos, Justice from the Board of Investments. Yeah, Justice, one of the growing trends right now in bids is for the parties to be likewise involved in international arbitration. That's the participation by parties. To a certain extent, Mr. Justice, would you advise it? Or up to what extent would state, which is the state of the disputing investor, be allowed to participate in international arbitration, Justice?
Well, I personally think it would add to the difficulties of the situation. You mean the home country of the investor would be allowed to intervene. That means you're referring to the ability to convert an investor-state arbitration into a state-to-state arbitrator. That's already allowed, except that it's not with respect to the decision of the tribunal that is there. It's the interpretation or construction of particular treaties or conventions. And you know what would happen there if there is no special arrangement provided for in international conventions. One or the other state may go to the ICJ, the International Court of Justice. But let me also tell you that it's not necessarily easier to do it that way.
Yes, ma'am.
Good afternoon, Justice, colleagues. I am Jane Yu from the Office of the Solicitor General. I just wanted to make a point with respect to the question that was asked about converting investor-state disputes to state-to-state disputes. First of all, if I remember it correctly, Justice, there's a provision in the ICSID rules that prohibits states from intervening diplomatically once a dispute has already arisen. And in a dispute has already arisen, if a case has already been filed before the ICSID, the reason being that the ICSID Convention wishes to judicialize the proceedings instead of converting it into a diplomatic proceeding between two countries. The second one is that there are provisions in the BITs pertaining to subrogation, and that is probably the mechanism by which an investor-state dispute can become a state-to-state dispute if, for example, a foreign investor buys into a foreign investment, a dispute, for example, between an investor and a state, and the state of the investor buys or subrogates into the dispute between the two parties. The other angle which could perhaps, sir, convert the dispute from an I to S to an S to S dispute is if the source of the funds, for example, are primarily from the host state, which not host state, but from the investor state, and such funds are invested into private companies, which would then invest into the host state, so that there is probably a complication as to the characterization of the funds that will be used for investing in the host state. So I would also want to elicit your views with respect to these matters. Thank you, sir.
Yes, you can see that that Solicitor Jane Yu has only difficult questions to raise. Yes, first of all, I would suggest that if you think it is easier to fight a state-to-state dispute than an investor-to-state dispute, you're wrong. Listen, a lot of things take place in the world behind the diplomatic curtains. No? there are hundreds of ways by which a respondent state can be influenced, you know, to do certain things, even against its own interest. Example, the flow of ODA funds. You know what ODA funds are, okay? And you know there are many countries, including our own, which is unfortunately heavily dependent on the flow of ODA funds. No? And then you have many difficulties. The level of competence of many of our public officials, you know, especially our negotiators. But I agree with you. Those points that you made are quite valid. They are there in the treaty. Okay. The only thing I'm really saying that it's not any easier. Okay. That, yes, ma'am.
Just one more point, sir. With respect to ODA, here, sir, we also would like to be clarified on the scope of what is protected investment and what is not protected. For example, the ICSID Convention pertains primarily to private capital. But we see, for example, in some of our negotiations and in some of our treaties, that investors would insist on including loans in the definition of what investments are, such that while in our BITs, the definition of investments is any asset, including 1, 2, 3, 4, 5, they would want specifically that loans be included. Now, this dichotomy may not be problematic if what we are considering are private loans. What about ODA? Such that you can no longer distinguish whether the funds that are being invested into the country are in fact sovereign in character and are therefore taken out of the convention, or whether or not these funds have become private because of your definition of what investments are.
Yes. Let me just say in respect of that is a matter to be dealt with in the negotiation of the BIT. That you have to raise that question in the course of negotiating a BIT. The Philippines has entered into a lot of BITs. I think there are, 73, 74 of them. Many of them are up for renegotiation. You know, the Department of Trade and Industry and the Department of Foreign Affairs must have the assistance of the Office of the Soldier in order to understand what problems arise. That's one of them. Okay. And another, of course, would be to take out the umbrella clause that is there, dangerous umbrella clause. Okay. But my hope is that the negotiators of the DFA and the DTI will know where to go, where they need assistance. You know what they do today? They send to the OSG completely negotiated agreements or treaties, you know? And they expect you to limit yourselves to grammatical errors and that kind of thing. It is during the process of negotiation that all of this has to be dealt with. And that is why I think the OSG has already the plan to form a special unit to assist other government agencies in negotiating with this. No? I don't mean to be rude, but you know, the ordinary Pinoy way of negotiating is to be nice to the other side, to give them what they want. That's what they really do. I once in the DFA asking a very senior official, bakit ho ninyo ginawa yun? As they told me, the answer was, yun ang gusto eh. You see. So you understand that the Pinoy is different. It's not an adversarial procedure for them. It's ask and you shall be given, type of situation. Well, I don't want to hurt anybody's feelings, no. That young lady over there.
Okay. One more question.
Good afternoon, Justice. Josephine Arias po. Sir, earlier you mentioned about the Petrol case wherein a witness was presented by a party in an arbitration, and the witness admitted that he bribed or gave money to an official. So, I would like to, can we say then, Justice, that there's public interest already, considering that there's an admission about bribery, paying a public official, which is violative of any state law against bribery. If there is a public interest involved, can the party or host, in that case, if there's a state party involved, can that state party ask that the confidentiality of that proceeding be lifted insofar as that official admitted to the bribery, and that transcript be used in the host state's law, in the host state, for them to file the necessary action against the official who was bribed and the investor who made the bribe? And if there's such a procedure for such lifting of confidentiality, Mr. Justice.
Well, I'm not sure whether such a procedure exists under the law of Azerbaijan. No? The applicable law there was Azerbaijan law. But I'm sure they reached, I'm sure both sides understood exactly what the situation was. That's why they reached some agreement. They didn't even let the tribunal know what settlement was reached, no? So, but the hearing was being held in London, and English law would apply according to the English member of the tribunal who now sits in the International Court of Justice, Sir Christopher Greenwood. No? He said that.
Justice, hypothetical question then. Assuming that that happened to one of the Philippines arbitration at the present or in the future, for example, in the ICSID, how can the Philippines, who has entered into a confidentiality agreement with the investor, seek permission either from the opposing party or from the tribunal that they, if they can use such transcript for their purpose, for the purpose of filing a case before the Philippine courts?
I don't think there has been an actual case of this kind, but I know the arguments that we would make if we had one of them. Okay. You say that the public interest, the ordre public aspect, overrides any undertaking of confidentiality, okay? And that the applicable law governing the investment is Philippine law. Another Philippine law, you cannot, there's certain things. And that's why I have to tell you that in the Terminal 3 case, the confidentiality agreement was not drafted by OSG. And it was a very conservative thing in favor of the claimant. Okay? As a matter of fact, as far as Piatco is concerned, normally a national of the host state cannot be a claimant against the host state in an international arbitral tribunal. Okay? But Piatco, a Philippine company, brought suit against the Republic of the Philippines in Singapore under the ICC. Okay? And why did they do that? Because it was in the ARCA, in the amended and revised concession agreement. And that was done after the Supreme Court in Agan versus, I don't know who I've forgotten, against the Republic, had already ruled that the concession agreement was null and void. But fortunately, before I forget, Piatco lost that case. The ICC tribunal kicked that out.
Okay. At this point in time, sir, can we ask you to give one conclusions, your last words on the topic before we close?
I have no last words. Maybe we should ask the Soldier to give the last words. Closing words. Pwede ho ba, Chief?
Good afternoon to everybody, and I would just like to thank you, sir, and to all who participated in this convocation, because this is a very, very important topic, considering that in the development of any country, investments are very important. They generate employment and capital. And it is very important that investors will have the confidence coming into the country that there is a level playing field here in this country. But equally important also is for the investor to know that they must come here with clean hands and that they must follow our laws. And that getting ahead by breaching our laws will get them nowhere, and the Republic will fight them. And as in these various international disputes that we are into at this point in time, we are fighting them because they have broken our laws. And it is useful for us practitioners and for the students of the law to know that at the end of the day, it is best to follow the rules, and that for the host state, for this country, to have rules that are balanced, that are fair, and that in the middle of a game, we don't move the goalposts so that the investors will be in a confused state of mind on what laws to follow. So I think at the end of the day, we have to find the balance, and that the way to move forward for this country and for the development of this country is to have a maturity in our laws, and for our people who execute the laws. Thank you very much, sir.
Thank you very much, sir.
Okay, thank you very much to all of you for joining us in this 11th Centennial lecture. We'd like to invite everybody for refreshments outside, but before we actually end, can we ask you to please stand up for the UP Law Centennial March? Thank you again, and we'd like to invite you for refreshments outside at the lobby.